In early April, Dane County Judge William Foust declared Wisconsin's right-to-work law unconstitutional. On Monday, he took the next step and denied a request by the state to issue a stay on the decision, which would have kept the law in effect until an appeals court could review the case. Attorneys representing both sides argued their case extensively, with the state's attorneys listing 4 key benchmarks for granting the stay have been met.
A stay pending appeal is appropriate where the moving party, 1, makes a strong showing that is likely to succeed on the merits of the appeal. 2, shows that unless a stay is granted, it will suffer irreparable harm. 3, shows that no substantial harm will come to other interested parties. And 4, shows that a stay will do no harm to the public interest. Regularly enacted statutes are presumed constitutional.
The attorney representing the unions made a more inflammatory case. After calling the state's position breathtaking, he said the reasoning would also uphold Jim Crow laws.
I say it's quite breathtaking because literally the state means if they pass Jim Crow laws, those laws would be regularly enacted, they'd be presumed constitutional, and the state would be presumed to suffer irreparable harm. So even though they were obviously unconstitutional, you would enforce Jim Crow under the state's theory.
He then cited the state constitution, asserting that the Constitution's takings clause makes right to work unconstitutional because the non-union members who benefit from union contracts are taking a form of property from the union.
Non-member employees don't have a constitutional right to have free services provided at the expense of other people's constitutional rights. And it's somewhat odd that the Attorney General is arguing against the enforcement of the takings clause, in effect saying, even though you have found that this is an unconstitutional taking, you ought to permit the unconstitutional taking to persist for an indefinite period of time.
The state's attorney pushed back against the Jim Crow comparison.
The plaintiffs bringing up the Jim Crow laws is just disingenuous.
He also rebutted the claim that unions are entitled to the dues of workers, saying that it's the unions that are unduly taking workers' property by compelling dues payments.
Plaintiffs also said that there's no constitutional right to take the property of another, but there's also no constitutional right to the dues or fair share payments of non-members.
Immediately after the arguments wrapped up, Judge Foust quickly went into explaining his decision, which he reached without breaking the hearing.
I don't think they're disingenuous in citing the possibility of Jim Crow laws.
Foust did not specifically address the constitutionality of the law, instead focusing on the union's concerns about so-called free riders.
The decision perhaps boils down to something as simple as there is no free lunch, there is no right to be a free rider.
While Foust weighed the probability his decision would eventually be overturned, he focused on the welfare of the unions in finalizing his decision.
I don't think, assuming I get reversed, the current non-members who are required to pay for the services they receive is not very significant irreparable harm compared to the size of the loss to be suffered by the unions if they're required to provide services without fees. I'll deny the motion for stay.
For the MacIver Institute, I'm Jen Healy.